evening and good morning, one and all present here in this webinar. I thank you all for sparing out your valuable time and being a part of this webinar organized by markpatent.org and sponsored by HK Acharya and Company. This is your host, Jalashri Dave for this webinar and a part of markpatent.org. I warmly welcome all of you. We hope you are staying positive and testing negative. With this webinar, we are accessible to a global audience that brings together a wide and varied group of people connecting in this digital world. Namaste. Before I start, I would share a quick introduction about our organizer and co-organizers. Organizer, markpatent.org. Markpatent.org, established in 2004, is actively associated property elements. The main element of the organization is to provide in-depth understanding and to create awareness of the intellectual property right among attorneys, advocates, professors, law students, and also among the manufacturers, industrialists, traders, and the general public. Markpatent.org undertake various activities at national exhibitions, seminars, lectures, and study circle activities to propagate the knowledge of intellectual property laws to the layman and thus creating awareness, developing recognition and acceptance of the intellectual property rights. Xavier's Research Foundation. The Xavier's Research Foundation Trust runs the Loyola Center for Research and Development, an autonomous institute which was established in the year 1987 in St. Xavier's College, Ahmedabad. Its goal is to do research in science and technology as well as in the humanities. Research, but also provide infrastructural support and expertise to the students working on the front field in environmental microbiology and plant biotechnology. The mission of the center is to target grassroots communities on the fringes of our economy and through innovation, entrepreneurship training, and handholding, set up production units at medium, small, and micro levels. GLS Law School. GLS Law School, a new venture of the Gujarat Law Society, fostering excellence in the legal education, is a premier destination for the students interested in the legal and making lucrative career in the law and aiming to be the torch bearers of justice. GLS Law School has emerged as the most preferred destination for the legal education, offering courses in multiple disciplines, imparting quality education across 2 campuses in Ahmedabad. GLS Law School and college is affiliated to the Gujarat University and offers BA LLB degree, which is recognized by approved by the Bar Council of India. The college has the advantages of the senior and well-experienced faculty members in the field of law. University School of Law, Gujarat University. The University School of Law in Gujarat University was established in 1977. It's one of the highest ranked law college not only in Gujarat but also occupies a top spot in the ranking of national level. It offers a 2-year full-time LLM course in intellectual property rights. ICFAI Law School, Hyderabad. The Faculty of Law, commonly known as ICFAI Law School, is a constituent unit of the ICFAI Foundation for Higher Education and is located in the lush green environments in the vicinity of the historical city of Hyderabad. The ICFAI Law School, with excellent and continuous teaching and learning process, student-centric and industry-friendly dynamic curriculum, as well as real-life exposure, provides best-in-class legal education to the student and carving them to market-ready legal professions out of the mediocre student who desires to making career in the law. UCSSI, United India Importers Council. It's a non-for-profit initiative started by the group of Indian SMEs, importers responsible for the imports for over $1 million from USA. It is only exclusive importers council in the world. USIIC act as an intermediary organization to facilitate partnership and trade between Indian and American business, and thus acting as a catalyst in promoting economic growth between United States and India. Once again, we are thankful to our organizer and co-organizers. So moving forward, may I please welcome our dignitaries. Managing Trustee at markpatent.org and proprietor of HK Acharya and Company, Dr. Rajeshkumar Acharya. Senior Advisor Projects and IPR Domain Expert, Mr. Padmin Bhuj. Patent Attorney, T&H Intellectual Property Attorneys from Beijing, China, Mr. Toby Mack. Associate at Zuber Lawler, member of Zuber Lawler Global from New York, Mr. Brian Beck. Partner, patent attorney, Beijing Resin Intellectual Property Law from Beijing, China, Ms. Cindy Lee. Partner, founder at Reisbeck and Castro from Colombia, Ian Reisbeck. European and German patent and trademarks attorney, Huber and Schussler from Germany, Dr. Andrea Schussler. Patent agent from Acharya and Company, Ms. Kinjal Shah. I heartily welcome all of you. So, ladies and gentlemen, it's my pleasure to introduce you Dr. Rajeshkumar Acharya, Managing Trustee at markpatent.org and proprietor of HK Acharya and Company. He is a patent and trademarks attorney and is registered to practice law before Indian and Canadian trademark offices. He is also a member of the Bar Council of Gujarat and have an extensive background in the field of litigation and prosecution of all IP-related matters. He is best known for his books on the IPR laws in India, which includes the patent law, the trademark law, the biological diversity law, and the design law. He has accumulated a wealth of experience in the prosecution and litigation of patents, trademark, design, copyrights, and other intellectual property-related matters. He is a member of various national and international organizations related to IPR and is also a member of Indo-American Chamber of Commerce and the president of US chapter of USIIC, that is United States India Importers Council. So with my utmost pleasure, I invite Dr. Rajeshkumar Acharya before you to share his piece of wisdom. Over to you, sir.
Thank you, Jalashri, for nice words. Good evening from India. As such, it is evening in India, but there is morning in New York, late evening in China, and maybe afternoon in Germany and different places. So I would like to tell good time, all of you. Dear friends, markpatent.org, it is a knowledge hub for intellectual properties mainly. We are organizing seminars since more than 15 years at international level in India. And we have always our speakers from different countries of the world. But maybe since last 2 years, it was impossible to have physical seminar. So we thought to have webinar and to invite speakers from different worlds. But the problem was timing. So we thought that evening in India will be the better time almost everywhere. Maybe a little bit early in US. Anyhow, I welcome all of you who are the galaxy, all of the galaxy of the speakers coming from different part of the world for boosting our seminar. This time, our webinar having theme, Booster Development of Pharmaceuticals. Since last 2 years, is Corona spread over entire. And it was such a dangerous virus. We could not find out how it comes, how it spreads, what to do. Even government also couldn't understand what steps should be taken. Even the doctors had never such experience. Even the pharmaceutical companies also having such what to do. Immediately they started working on the vaccines. And it was a trial and error for pharmaceutical companies, for the doctors, for the government, how to save ourselves. we can stop declining the economy. It was not easy for any government, any person, any people, any doctors, any pharmaceutical company. Only the business was running of the pharmaceutical companies for day and night. They were trying to develop something, some medicines, some vaccines to stop these changes. And as far as the patent is concerned, IPR is concerned, many government didn't allow pharmaceutical company to have the patent for their developed medicines or vaccines. Anyhow, things are improving almost everywhere. And until now, we were thinking that humankind can do anything, but we could understand our limitation. And we develop ourselves very much in this period, and things are improving almost everywhere. And with this preamble, this is an appropriate subject for booster to development of pharmaceuticals. We have the galaxy of speakers who can share their knowledge. All of us, I welcome all of you. Thank you.
Thank you so much, sir. It is under guidance of Dr. Rajeshkumar Acharya that HK Acharya and Company is now a team of highly qualified and expert visionaries. So this webinar will have series of sessions which will give a flavor to the remarkable diversity of the subject matter of IP, that is booster to the development of pharmaceuticals. So now let's start the interesting session covering the subject matter with our very first speaker, Mr. Padmin Buj, who is a national level IPR domain expert. Presently a senior visiting faculty with Entrepreneurship Development Institute of India. He is also a project and management advisor. He holds about 30 years of combined experience of intellectual property rights, corporate industry, project management, entrepreneurship development, and academics. Mr. Booch, as the managing director of JITCO, established the patent cell at JITCO. He received the GTO Pedagogical Award for the contribution in the IPR in the year 2013, and recently in the year 2018, he was conferred with the prestigious IP Samaritan of the Year 2018 award by IPPO. He has also been invited as a speaker at the national and international conferences and seminars on IPR. On official work and assignments, he has visited widely across the globe. He has completed B.Pharm, MBA, CMC, PG Diploma in Patent Law from Nalsar University, Hyderabad. So now I request him to present his thoughts with us.
Thank you, Jalasri, and thank you, Dr. Rajeshkumar Acharya, Omkar, the entire team of Mark Patent and HK Acharya Company. Well, I am a part of the entire family of HK Acharya and Mark Patent. But I always consider it's a great honor, privilege, and pleasure to be part of this webinars and conferences organized by Mark Patent. This is truly an international webinar, I must say, with all the friends and experts from all over the world having joined on one web platform. And I must give credit to Dr. Rajeshkumar Acharya. I was saying to Omkar that I am the only one who not outside India, because I consider Dr. Rajeshkumar as a multinational. He represents so many countries, I would say, in that way. So welcome all of you colleagues, and I hope to give justice to when I'm invited as a part of this kind of esteemed panel of speakers. Look, yes, my basic background is pharmaceuticals. I work in pharmaceuticals. I am also director on the board of one of the very innovative and known pharmaceutical company. It is based in Ahmedabad but operates all over the world. And IPR, I started working since several years and learning a lot from Dr. Rajesh Bhai over a period of time. Yes, IPR is a booster to pharmaceuticals. There is no denying to the fact. That's a fact. Or is it? Now that is the point. Is it IPR a booster to pharmaceutical or not? Now, why I'm asking this question, although it normally you may feel the answer is obvious, is that there are several also undercurrents going on. I have a presentation. In my presentation, I am going to talk about briefly about the Indian pharma industry, then how IPR helps pharma industry, and also point out a few issues when we talk about IPR and pharmaceuticals. We should not ignore that part also, but we must, at the end of the day, we must encourage IPR in pharmaceuticals, and that's what Rajesh bhai very nicely put together. I have a presentation to share, which I will share it now. So, intellectual property booster to the development of pharmaceuticals. Very apt title, and I always say that Dr. Rajesh bhai and his team comes out with a very, very apt and proper title always of such kind of webinar. Okay, this is of course. Let us have an overview of the pharmaceuticals, because we are talking about the pharmaceuticals today. There is no denying to the fact. It's on record. Global pharma industry or global pharma market or global manufacturing of pharma or sale of the market, whatever you say, it's always going up, 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 and up. And the recent years have been no exception. It is going as a galloping speed. And this shows a little different kind of classification and analysis of various countries, how they are placed. What is important, according to me, are the statistics given for the what is called emerging market, market or countries which are emerging in the field of pharma as compared to the developed countries like USA, maybe Japan or European Union. Okay, emerging countries in the field of pharma, and of course India itself. Now, if you see the India, the CAGR, compounded annual growth rate in terms of percentage, is something between 10 to 13% in the last 5 years. This is significant CAGR, my dear friend. And that is why India as a country is placed very strategically and importantly in the global pharma market. Indian pharmaceutical scenario, giving a quick eye overview. The domestic pharma industry of India is expected to grow at about 11% year by year to cross US dollar billion, 60 billion in the market size. These are the figures by a very reputed agency called CARE and a very recent assessment done by them. Pharmaceutical exports from India with a compounded annual growth rate of 10% is estimated at 24 billion US dollars in the financial year 2021. India at present ranks third globally in volume terms and 13th in value terms. Why? It is known why India produces a huge amount of pharmaceuticals. So it is naturally third globally in volume. Why it is 13 in the value term? Because of more than one reason. One of the key reasons being the medicines and pharmaceuticals are priced lowest or one of the lowest in India as compared to the world. It's a fact. Why? Firstly, because we have got a large number of small and medium pharma companies operating in India. There is an element of competition and everybody wants to keep the price at a competitive level. India also has a very effective drug price control order, a drug price control mechanism, which also take care of it. So India produces a quality medicines, quality pharmaceuticals at one of the lowest prices, and that is why in value terms it is third. It is also a fact that if India produces more value-added products with a higher contribution, then this rank may go up. All this growth, which is a fantastic growth by the Indian pharmaceutical industry, is driven substantially, if not entirely, by what is called generic opportunities available globally. Generic, as we know, all the pharmaceutical products which are off patent. And no doubt, no wonder India is from as a pharmacy of the world, particularly pharmacy of the third world countries because of its generic dominance. This is the an estimated projection given by a well-known report, well-established, well-proven, well-accepted report by McKinsey and Company, one of the world's largest management consultancy firm, of India Pharma 2020 report. What it shows, it says that at a conservative or pessimistic CAGR, compounded annual growth rate of 10%, and at the optimistic level or aggressive case of 17%, India's size of the pharmaceutical market will be $35 US million or $70 US billion. If we take a middle path, still we are almost 60 billion, which I just mentioned in my earlier slide. My dear friend, it's not a small figure. India has established as one of the major pharma industry in the world. These are, just to give an idea of my friends, these are the three zones, pharma zones. Actually, pharma industry in India is spread all over the country. But these are the three distinct zones. One is the northeast region and north region. The other one is the western region, the Gujarat state from where we represent, and Mumbai, Maharashtra are part of the western region, one of the major zone. And the third one is the southern part of the country. In terms of the specialization, if we can classify that manner, our product focus, the Western India, what is called Mumbai, Gujarat axis, its product focus is bulk drugs, formulations, and merchant exports. Gujarat being more tuned to the formulation. Northern India is more or less similar kind of product focus, but of course, Western region is a much more dominant, much more ahead. In southern part of the country, where the Chennai, Hyderabad axis is there, it is primarily bulk drugs or maybe what is called API, active pharmaceutical ingredients. There are also some formulations. This is to just give an idea of what India is in the field of pharmaceutical at the global level and within the India itself. Okay, it was necessary because if we talk about pharma industry and IPR, we have to know where we stand, where India stands, and what is in future for Indian pharmaceutical industry. The future is good, my dear friend. IPR. IPR is something which I believe gives a competitive edge. No, it's a competitive world and everybody is racing. But everybody is not racing in the right manner. These four people, four gentlemen are racing because somebody ahead is racing. No, this will not give you the competitive edge. Innovation is something which is going to give you the competitive edge. Innovation of any kind. Innovation, this is also innovation. Somebody comes with a capsule which is a medication and also ingredients so that you don't have any side effect. But it doesn't say how to swallow the capsule. Of course, my dear friend, it is in a lighter manner, but it is an innovation. But the innovation, what I am talking about, is which is a viable business-wise. It is desirable in terms of the human need. And of course, is feasible, implementable. And this kind of innovation doesn't have to be a very big innovation. It could be small innovation, but workable innovation. Small innovation, which are viable innovation. Small innovations, which adds market value and people will go for that. And when we go for such workable innovation, it creates intellectual property. And that is the fantastic concept of intellectual property. You do innovation, create, add market value, and create what we call intellectual property, which is essentially intangible property. And it is the intangible property which is taking the world ahead. You pick up any country or any company or any institution, they are ahead if they have done innovation, if they have got a patents and IPR, which is essentially intangible property. And that is why it is said that in a country like USA or many other countries also, the companies which are ahead, they have more intangible assets in their balance sheet as compared to the fixed asset. This is the intangible assets which are essentially intellectual property based on innovation and research, which is making them competitive and taking them forward. And IP, as we know, is a creation of mind. And intellectual property right gives the right of ownership, and that is the booster, my dear friend. Once you have done innovation and you get a right over your innovation, for whether it's a trademark, whether it's a design, or whether it's a patent, the ownership right is something which is a motivating factor, a booster to go for further and more important and meaningful innovations. Because we are part of the knowledge economy. The world economy has sent the paradigm shift over a period of years. There is agri economy, there is industrial economy, but knowledge economy is all pervasive. The utilization of knowledge, IT, for example, is everywhere. And in knowledge economy, what we do? We do innovation, we do research and development, we utilize science and technology. But if we don't protect under IPR, what's the use? So it is a knowledge economy, and drugs and pharmaceutical industry, as all of us appreciate and acknowledge, is a knowledge industry. And that is why intellectual property right, IP, is a booster for pharmaceutical industry. There is no other industry other than drugs and pharmaceutical which is having the maximum utilization and impact of intellectual property right and its provisions. The India had witnessed this when in the year 2005, we changed over from process patent to product patent. And we know what was the kind of turmoil it took place, because it is directly affecting the pharma industry. Pharma industry was the most affected. So how it is booster of IP in pharmaceutical? How and in what manner? What it is? These are the main drivers, as I said earlier also. Leveraging opportunities arising out of the patent expiry of globally well-established drugs. India is well placed. Indian pharmaceutical industry, and for that matter, several other countries' pharma industries are well placed. What is happened? The moment, the patent has a life of 20 years, most of the time. And as the 20th year approaches, the pharmaceutical industry of India and such countries are ready to move in with an off-patent version of the same product, what we call generic drugs, and they immediately enter the market with their version of the generic drug. This is one of the biggest opportunity, my dear friend. It's one of the main driver for drugs and pharmaceutical. IPR plays a role in direct manner in this case. Here is the expiry of patent which plays a role. The patent has encouraged and motivated companies to come out with an innovative product for 20 years. World has taken benefit. Now the entire world takes the benefit by the same drug coming in the generic form. So generic market side itself is a big deal. It's one of the huge market, generic market. Then there is a product called NDDS, innovation, new drug delivery system. Countries like India and the pharma industry of the countries has taken a big advantage of this innovation method. Everybody cannot go for original molecule, you cannot go for the original formulation, but changing the delivery of the particular formulation or a drug has yielding fantastic result. Is one of the major driver or booster for pharma industry. Process patent. When India introduced product patent in the year 2005, India continued with the process patent. And I always emphasize, particularly pharma industry and researchers and academicians in India and such kind of countries, That don't forget that process patent has its own value. If a company or a person is manufacturing product, is a patent for 20 years, product patent. But if he gets a better process to manufacture the same product, he will go for it. So process patent remains one of the major driver of booster for pharmaceuticals, of course. Then there are other drivers like ebbing of the regulatory risk, particularly when the industry becomes more knowledgeable and familiar, and de-risking strategies from dependence on China for key raw materials. That is specifically India-specific driver. India and Indian government and the Indian pharma industry is in a major drive. China is a fantastic country. China, there is a lot of to be learned from China in general and in pharmaceutical industry in particular. And India is in the process of developing itself to see that we have our own products, particularly raw materials for pharma industry. These are the major drivers. It gives the government of India has come out with the slogan of being a self-reliant. It is one of the major booster for pharma industry. Patents contribute up to 80% of the overall revenue of the pharma industry, and that one can realize why it is a booster. Obtaining patent protection is important to safeguard the innovations. Drug patents help recoup investment that are incurred during the research and development stages. My dear friend, these are the boosters. These are the motivators, if we could call them. There are various kinds of patents found in pharma industry. People know, but I must emphasize to make it they are obvious. There are the molecules. It could be pharmacological compound or active metabolic. It could be protein, DNA, or antibody. Then there are processes, as I mentioned very clearly. There could be manufacturing process, there could be purification process, there could be diagnostic process. All are patentable, all have been patented, occupying a major and vital segment. Composition formulations, new composition of 2 or more ingredients, or totally new formulations, which could be extended release, gel, patch. There are others also. Others innovations for which patents have been done, diagnostic tests, research and development technology, devices such as inhalers, specific form of molecules, ranging starting from innovators, isomers, polymorphs, salts, esters, and of course, as we said, NDDs, new uses, indications. Compounds are second use of the same product, which we have seen as a repurposing drug in the present pandemic of corona. Okay, so there is a great range. A patents grants right to exclude, right to market comes from authority. There are other claims to the pharma industry, as we can see, compounds of various kind, use of compound in a particular therapy, and of course, pharmaceutical composition comprising our compound. Vaccines, as Dr. Rajeshkumar mentioned, vaccines is a classic example of how pharma industry can contribute to the world, and that is where the discussion and debate on patenting comes. It's a research product by the companies who have worked upon it. Whether patent is going to restrict its availability, yes, it's a big booster. An innovator must get patent, but should it be restricted during the pandemic times? So these are the, in nutshell, these are the various kind of patenting in pharmaceuticals: a new pharmaceutical formulation, a new active pharmaceutical ingredient, a new drug intermediate, NDDs, and new process. Generic, I will take a couple of minutes to talk about generic. Generic has taken the world by storm. Even the developed countries also, if they get the better quality pharmaceutical at a cheaper price, they go for it. And that is the unique selling proposition of generic drugs. A generic drug is a copy of original drug whose patent is ended, is sold under its generic name or an adapted name. The cost advantages is almost 80 to 85% lower than original, because the original research work has been done by the innovator, which has a patent for 20 years. Because there is no R&D cost involved. Any drug manufacturer can make them after approval from the drug controlling authority of respective country. Okay. Does lower price mean inferior quality? No, not at all. A generic drug is the same in terms of chemical composition, dosage, safety, and strength. And that is why generics are the biggest booster for pharma industry. In the year 2022 alone, patents of more than 30 drugs valued at around 100 billion US dollar are likely to expire, which is the potential for generic drugs. And market size of biosimilar drugs, which are a generic version of the biotech products, is estimated at US dollar 350 million. So this is, my dear friend, one of the biggest booster for pharmaceutical, which is in a way part of IPR. At the same time, as I mentioned earlier, there are some issues. Issues in the sense that there are differences of opinion. Compulsory licensing. India has a provision for compulsory licensing as a part of its Indian Patent Act. And so are a few other countries also. What is compulsory licensing, as we all know? If a particular patented drug, which is a life-saving drug as classified by the WHO, World Health Organization, is not available in the required quantity, or is priced very high even after 3 years of granting the patent in a particular country, the government of that particular country can request the patent holder to make it easier availability and reduce the prices. If it doesn't happen, the government of that particular country can give license to another firm in that country which can manufacture the same product, same quality. Compulsory license is a debate many countries are not in favor of, but this is a WTO compliant provision in Indian Patent Act, my dear friend. And so far, India has only one case of compulsory licensing. The next hour, the oncology drug for kidney, the next hour by Bayer. Okay, it is, but these are the provisions. These are the key issues in pharmaceutical. This, in a way, encourages the pharmaceutical research. Evergreening is extension of the product patent beyond 20 years. India, under Section 3D of Indian Patent Act, does not allow incremental or marginal innovations to grant further patents. Okay. India also has a pre-grant and post-grant opposition. One can oppose even before the patent is granted, and within 1 year of granting the patent, one can oppose. And traditional knowledge. Traditional knowledge is one of the biggest opportunity area in the world of alternate medicines. But traditional knowledge cannot be patented in a direct manner. You require several structural modifications to make a product out of traditional knowledge or traditional herbs to make it patented. Traditional knowledge is one of the biggest opportunity area for the world as a whole. India, country like India has a great biodiversity, and India has a huge potential to go for it. But the patenting part of it is a sensitive matter in traditional knowledge. We cannot allow anybody to patent the traditional knowledge and medicine in the raw form. It's in public domain. It is for everybody. Okay. The cases of turmeric and cases of neem are very well known. I would just like to mention that Indian government has come out with a fantastic documentation, what is called Traditional Knowledge Digital Library, TKDL, which has thousands of entry of medicinal plants of India, so that nobody can get a patent on that, including in India. Okay, so these are the issues shown in a graphical manner. As he said, the shift from process to product patent has been a major change for Indian pharma industry. But Indian pharma industry was ready after a couple of years, and they have come up to the task. Evergreening, as just discussed, compulsory licensing, there are subsidies for IPR voting and IPR community rights and indigenous knowledge, as we just talked about that. Overall, one of the biggest issue is right of the innovator versus availability of at affordable prices to the large section of society, which was being debated, still debated in terms of vaccines. It's a live debate whether the innovator should get the right once it innovates medicines or pharmaceutical. Yes, that innovator must. But if it is a product like vaccine in a huge pandemic like COVID, will it come against the affordable distribution to the world at large? We have to discuss this issue. Yes, IPR is a great booster to the pharma industry, and those who have known that, those who appreciated that, they are taking advantage of that. But this a few issues we also understand. Okay, so this is what it is. What I just now balancing of encouraging innovators, and also taking care of national economic goal, national socio-economic conditions. Okay, this is a very crucial issue, and so far we have been able to take care of it, but it needs a further policy formulation on that. Okay, let me conclude. IPR booster for pharmaceuticals. Yes, IPR provides fair and effective incentives for innovative processes. It also provides a strong enforcement mechanism for defending infringement in the case of patented drugs and even patented processes. And IPR paves way for rightful market linkages for the patent holder. It is the IPR which plays an important role in facilitating the process of taking innovative technology to the marketplace. This is a very important thing to keep in mind. Ultimately, innovation has to get to the market, okay, for the utilization of the society and business. And once we are protected, it is easier for the innovator to go to the market and make use of it. So these are the, again, I am repeating, opportunity in the pharmaceuticals. All of these are important. Traditional medicines, I must emphasize, is a domain to be looked into and work upon. The time has changed. Pharma is no more pure pharma. I have been talking to pharma industry innovators. They say a lot of engineering technologies are part of the pharma now. Artificial intelligence, machine learning, Internet of the Things. All the repurposing the drug like remdesivir, okay, and favipiravir, and even the vaccine formulations have utilized greatly the artificial intelligence. These are also the booster, my dear friend. And it is the institutions and academics where the research takes place, giving way to innovation. And that is why it is said, industry academic interface is something which has to be continued and encouraged more and more. One can work jointly, one can share the rewards, and this is what it is called research to revenue. This is something which we are looking forward to. Or our Indian Sanskrit language, it is called Saraswati to Lakshmi. For my dear friends from outside India, Saraswati is a goddess of knowledge. Lakshmi is a goddess of wealth. So from research to revenue. And that is why we say, please invest in innovation. Invest resources, time, money, everything. And I would end by quoting our Honorable Prime Minister. It is the mindset which is important. The mindset to utilize knowledge and IPR in the right manner to create a knowledgeable business and knowledgeable society. And that is what IPR is all about. And that is what the use of IPR in pharmaceutical all about. Thank you so much. And once again, thanks for giving the opportunity to share my views. Okay, thank you so much.
Thank you very much, sir, for sharing such a thought-provoking presentation. So, moving forward, let me introduce our next speaker, Mr. Toby Mack. He is a current co-chair of the AIPLS IP Practice in China Committee and an active member of the Asian Practice Committee of the IPO. He has completed PhD in chemistry and the only Chinese patent attorney working in the Beijing Chinese patent firm from the Hong Kong. He is trained under the UK system and took the UK CIPA examination and has also passed some of the papers. He is responsible for publishing articles on China IP and give updates for the UK CIPA Journal. He is a member of AIPLA, IPO, and UK CIPA. So now I request him to present his views with us. Over to you, sir.
Thank you for the introduction, and we will share screen. Can you see my screen?
Yes, sir.
Good. So let's get to the business. Well, thank you for your introduction, and I believe I do not need to go through the introduction of myself so extensively. So I will just talk a little bit about my firm T and how I have been with them since 2010. So it has been 11 years. This is a Chinese IP boutique firm that does only IP work, but of course within the IP area, do all sorts of IP related services, from prosecution to opinion, invalidation, litigation, advisory, and so on. We have about 220 people now. Most of them are in Beijing. I myself spend most of my time in Hong Kong. Why? Because there is a client in Hong Kong requiring me to go to their place to be at their part-time in-house 1 day per week. And this Hong Kong client is the Hong Kong Hospital Authority. And because of them, a lot of my work is pharmaceutical related. With the hospital authority, my work is extensively just to do their freedom to operate work on the drugs they purchase. And we do about 50 freedom to operate exercises per year, give and take. So it is a lot of, that's how I gain my drug freedom to operate experiences from. This is my favorite part. It's about my informal introduction. Don't ask me why, but before I entered the university, I did a year of database programming. And that's how I gained my computer knowledge. And that's why in addition to chemical and drug patents work, I also do a lot of software related work. As I said, I now spend most of my time in Hong Kong, mainly because of the Hong Kong Hospital Authority. I'm known to be a troublemaker at IP conferences, and if you want to know why, just look at my initials. And don't worry, I'm not famous Christian rock star Toby Mac, and I would not sing. I'm an very addicted video gamer, and believe it or not, my Japanese is learned by playing online games. And I'm also a comic and anime lover. If you know all of the above, I'm sorry about that. So there's the usual disclaimer. Let's skip that. So these are several topics I want to talk about. First is about the US and China trade agreement. And then I will talk about the Fourth Amendment to the Chinese patent law, which also introduces the following items: Chinese drug patent linkage, term adjustment, drug patent term extension, and drug patent linkage database. So the US and China trade agreement was signed in January 2020. This is very significant with respect to intellectual property, because this trade agreement requires China to adopt a lot of US practices in China. This is reflected by the Chinese patent law, the unfair competition law, with respect to a lot of trade secret issues, copyright law, trademark law, and so on. And we will see in more detail on how these trade agreements affect the changes. Chinese patent law, the Fourth Amendment, was passed last year in October and was effective on 1st of June this year. There are a lot of changes, but only the items I highlighted are related to drugs, in my view. They are drug patent linkage, patent term adjustment, which is due to the China Patent Office delays, and drug patent term extension, specifically directed to patents related to drugs only, and increased compensation for patent infringement. These improve infringement damages. Partial design is allowed. This may be relevant to designs of some pills, shape, or medical devices. Let's go into more detail on the topics of drug patent linkage in the next one. In the next slide, the Chinese drug patent linkage system is quite similar to the US system, but only on the surface. Similar to the US, there are 4 types of declaration under the system. Oh, by the way, the drug patent linkage system in the US, the main use of it is to prevent the generic drug applicants to obtain marketing approval easily when there is a patent around. The major purpose of that is to delay the approval as long as possible. So under this system, similar to the US, there are 4 types of declaration when a generic drug applicant is going to apply for drug marketing approval, EMA. They include, there's no patent information, it's straightforward. We can then just go straight ahead to obtain the drug marketing approval under the usual process. The patent has expired or has already been declared as invalid. Again, it's straightforward, no patents is involved. The declaration type 3 is commit market only after the relevant patent has expired. And the last one is contentious one, is that it is considered that the patent is not infringed or is invalid. So what is one major problem about this drug patent linkage system? In my view, is that it treats chemical, biological, and Chinese medicine drugs differently and very differently. Like, for example, for the chemical drug, the active pharmaceutical ingredient, API, composition, and indication could be registered for the drug patent linkage, while for biological drug, only sequence listing and indication could be registered. And one big disadvantage of biological drug is that drug marketing EMA be processed to grant as usual, regardless whether there are patents registered or not. For Chinese medicine, again, there are restrictions on only the composition, use, the indication, and extraction patents could be registered for the drug patent linkage. I'll have a more detailed demonstration of what this drug patent linkage database is about in the later part of my presentation. So another issue for the Chinese drug patent linkage system is the difficulties to invoke the suspension of the generic drug marketing approval and the tight time schedule involved. Suspension of the generic EMA approval is the whole essence of the drug patent linkage system. First of all, as said in the previous slide, the process at the Chinese FDA equivalent, NMPA, only be stopped for chemical drugs in any event. Sorry for biologics, and Chinese medicines. Even for chemical drugs, for declaration type 4, if the generic supplier only challenge that the relevant patent is invalid, the EMA drug marketing approval owner could do nothing. Specifically, the Chinese court and the Chinese Patent Office relevant patent linkage measures do not accept cases in such a situation. What is left is the generic supplier challenged the generic drug does not fall within the scope of the patent. In such a specific case, in order for the process at NMPA to grant the EMA to stop, it is necessary to have a court or the CNIPA to find the generic drug at issue in fact falls within the scope of the patent. This is what I call the pseudo infringement complaint, not an actual infringement, the determination of whether the generic drug at issue falls within the scope of the patent. The current system has a tight time constraint to do so. Specifically, complaint must be accepted by court of the CNIPA within 45 days of the publication of the generic drug application. After the case has been accepted, the decision has to be made in 9 months. Otherwise, the EMA could process as normal, as if the drug patent linkage does not exist. If you have ever filed a case at the Chinese court, you would then be familiar with the heavy formality requirements. For example, for a foreign entity power of attorney, certificate of incorporation, court resolution appointing the representative. Signing the power of attorney does not need only to be authorized, but also have to be legalized. This is extremely challenging. We are taking into account the 45 days limit. So that's why my view is now, well, China very favors generic in my view. So the next topic I want to talk about is patent term adjustment. This is not only available to drug patents, but all patents granted on or after 1st of June 2021. The law requires the term to be adjusted for patents granted after 4 years from the application date, after 3 years from the date of filing the request for examination. According to the current draft, the patentee has to apply within 3 months from grant, and these are considered as not reasonable delays. This, for example, including first action not responded to within the deadline, this extension has been obtained, delay for examination requested, incorporation by reference has been invoked, or suspension due to owner's ownership disputes. The current calculation appears to be any time after the above AM, that is 4 years from the application date, and after 3 years from the date of filing the request for examination, minus all of the not unreasonable delays 1 to 4 above. So in addition, the term adjustment is for a drug patent, you can first obtain the patent term adjustment first, and then you can still apply for patent term extension. In the law, there are 2 limitations. I call them the 5 years limitation, is the term extended cannot be more than 5 years. 14 years limitation, that is the total effective patent term after the new drug has obtained marketing approval in China is not more than 14 years. The draft currently says, well, again, it has to be applied at the CNIPA, Chinese Patent Office, in 3 months from the date of the drug marketing approval. The requirement is 1 drug can have only 1 patent extended, and 1 patent can only cover 1 drug. This is what I call the 1 drug, 1 patent, 1 patent, 1 drug requirement. The PTE term extension to be granted, very simple. Calculation is very simple. It's the date of drug marketing approval minus the patent application date, and then minus 5 years. Let's have a look into 2 examples. Assuming we have patent with filing date of 10 June 2021, and the original patent term would expire on 10 June 2041. 2 different examples. In the first example, let's assume the drug marketing was granted on 10 June 2032. Remember, it is the date of grant of the drug marketing that matters, not the date of grant of the patent. So according to the calculation, it's 6 years. However, because it is over 5 years, 5 years to be granted, and therefore the patent term would be extended to 10 of June 2046. This is just within the 14 years limitation. Let's look at another example. Is that drug marketing approval granted 2 years earlier. Now, the patent term extension, according to this calculation, is 4 years, which is within 5 years, and therefore 4 years to be granted. However, because it would then extend the patent term to 10 of June 2045, which exceeds the 14 years limitation, the patent term could be extended to 10 of June 2044. There are further limitations on the drug patent term extension in the current draft Chinese examination guidelines. Good news is for innovative drugs that have not marketed in China could generally obtain such drug patent term extension. However, for improved drugs, only specific ones could obtain such PTEs. They include chemical drugs that form esters or form salts with the non-active ingredients, chemical drugs with new indication, vaccines with approved strains, therapeutic or medical products with new indication. In Chinese medicines with new functions and main treatments, there are several improved drugs that could not obtain term extension according to the current draft of the Chinese patent examination guideline. They include drugs that contain optical isomer of known API, and drugs contain active known ingredients with new dosage form. And there are further lists of improved drugs that, according to the current draft, cannot obtain patent term extension. I'm in the process of drafting comments to the CNIPA and for the IPO and the IPLA, and my general opinion is I believe all improved drugs should be qualified to obtain patent term extension. So let's have a look at the China Drug Patent Linkage Database. How does it look? The database is accessible at this link, and you click onto that, you will see a page like this. Here is where you register drug information onto the platform. Here is patent information publicity, is that you can search for drug patent information already registered. And the next one is patent declaration, that is for searching declarations filed by direct drug applicant against a particular drug. Sorry. You click into the patent information. Actually, it is called patent information only. Click into that. This is the page you will see. You will see 3 tabs. You divide them into Chinese medicine, chemical drug, and biological drugs. Oh, by the way, I'm sorry, this database is available in Chinese only. So don't ask for an English version. Hopefully that would be available, but I don't believe that is available in the near future. I mean the English version. So you can see there are already quite a lot of drugs that have already been registered. By the way, this is only the page on 19th July 2001. The page when I finished my article, the unofficial user guide to CN drug patent linkage database. If you're interested on that, let me know. I'm happy to share that around. So if you look at the numbers right now, it would be a lot more. So you can search for particular. I'll continue with the introduction of the Chinese drug patent linkage database. As we can see from this screenshot, you can do a partial search, of course in Chinese, for a particular drug. The particular drug I'm looking for is Verbocilib, and I use the partial name of its Chinese name to do a search, and you will see the 3 entries here. So if you know Chinese and you know the Chinese names, this is not a difficult way to search for a particular drug in this database. So you click into a particular entry and you will see all of this information, which in my view is very extensive. They include, of course, the patent number. They also include a link, respective links to click to the grant publication of the relevant patent. And even more so, they also include the specific division as declared by the patentee of what claim is covering what aspect of the drug. Like, for example, like here, it says claims 1 and 2 are covering the active ingredients of the drug. And it specifically put down the patent expiry date. Even more so, it also includes that this patent has survived through an invalidation challenge and survived. All this information is very extensive, and I have not seen equivalent extensiveness as in other places. For example, in the US FDA patent linkage, the US equivalence Orange Book, what you have is only the patent number and the expiry date. So as far as freedom to operate is concerned, this is a mountain of treasures, because once you click into here, you can see what claims is covering what aspects of drug, and whether the patent has survived through invalidation. All this information would be available. So let's click into a particular declaration filed by a generic drug supplier. This is here you will see the particular drug, the owners of the drug marketing approval, its registration number, and here is the most important thing: is a type of declaration file. Here is type 3, for which the generic drug supplier promised to only put the generic drugs onto the market after the patent has expired. And here, in fact, you will see this drug patent linkage database divides type 4 declarations into 2 types. They call it type 4.1, which sets the patent at issue should be declared invalid, only should be declared invalid. That is, they promise to challenge the validity of the patent. And type 4.2, for which the generic applicant alleges that the generic drug does not fall within the scope of the patent. This is only type 3 because at the time when I wrote my user guide, only type 3 declarations was filed. Shortly thereafter, on 23rd of July, the first type 4.2 declaration was filed. I'll be happy to share more details on that if you are interested. So several takeaway messages. This could be good news for generics because the drug patent linkage system in China, in my view, is very generics friendly. For example, if you file a type 4.1 declaration, that is, you try to challenge the patent is invalid, then you already obtain a green light to obtain your drug marketing approval. Well, on the other hand, there are also good news for drug innovator. At the very least, you now have drug patent term extension, which was not available before. And in addition to that, you also can enjoy patent term adjustment. So is this a balanced system? Well, let's wait and see. And finally, there is extensive information that could be obtained from the Chinese patent linkage database, for which freedom to operate exercise would become more easier. So this is the end of my talk, and thank you for listening.
Thank you very much, Mr. Mack, for discussing the topic in a very comprehensive way. Let me introduce our next speaker, Mr. Brian Beck. Mr. Brian has represented Chicago Financial Services, an expert services firm, at trial against the former partner and managing director in complex litigation involving claims for the breach of royalty agreement, breach of operating agreement, tortious interference with the prospective business advantage, and misappropriation of the trade secrets. He has also represented software patent owner at federal circuit in the appeal of summary judgment of invalidity based on the unpatentable subject matter and indefiniteness as an owner of the patent on a virtual reality camera and rig technology in infringement lawsuits against major California and Chinese photography companies. He has defended generic pharmaceutical company against allegations by major US pharmaceutical company for the breach of confidentiality agreement and trade secret misappropriation, and also defended major Indian generic pharmaceutical company and US subsidiary against the allegations by major US generic pharmaceutical company for the breach of non-compete agreement and trade secret misappropriation concerning the transdermal patches, and has also advised the clients regarding the trademark prosecution and copyright and trademark licensing, and currently working with the Zuber Lawler Global. So now I request Mr. Beck to share his knowledge with us.
Thank you. And there's just one small correction to the program. While I am admitted to practice in New York, as well as Illinois and the US Patent Office and the Federal Circuit, I am currently in Chicago. So let me pull up my slides. Go. All right, that should work. So today's topic, intellectual property, booster to development of pharmaceuticals. I would dissent from this a little bit. Intellectual property certainly is a booster to development of pharmaceuticals, but when intellectual property rights go too far or are not properly limited, they can become a barrier to development of pharmaceuticals. As just mentioned, my career, the first 8 years of it, I spent largely representing generic pharmaceutical companies and trying to deal with the challenges of generics who were restrained by overly broad patent rights. And today I'd like to talk about how the Federal Circuit in the United States has been making things harder for generics by broadly allowing method of treatment patents to extend the life of branded drugs beyond the limits that they should have. So I'll start with by showing you this comic, and unfortunately with the webinar I can't hear if anyone is chuckling at it. But the issue with method of treatment patents is you have a lot of drugs that are relatively old drugs. The original patents to the composition of matter or to the original treatment have expired or are soon to expire. And the branded companies want to extend their period of exclusivity, want to extend their patent rights. So what they'll often do is find from their clinical testing and their clinical studies, they'll find that the drug works slightly differently in some subpopulation of patients, and then claim a method of treatment to treating those patients slightly differently with that drug, get a new patent on it, and suddenly they have patent protection that lasts longer than the 20 years that the bargain is supposed to work for. So that hence the comics reference to protection by patents for trivial and incremental improvements. So for example, one such drug that I am familiar with, Endo's Opana ER drug, an oxymorphone drug. This is an opioid painkiller. The drug was developed in 1914. It was first patented in 1959. But Endo, in addition to using patents on extended release formulations of the drug and then crush-resistant formulations of the drug, obtained a patent, patent 8,808,737, obtained a patent that expires in 2027 that claims the method of treatment of treating pain in renally impaired patients by giving them lower doses of extended release oxymorphone. Basically, during clinical testing, they discovered that oxymorphone is effective in renally impaired patients with kidney damage at lower doses. So they claimed in their patent the method of treatment of giving such patients lower doses of oxymorphone while keeping the average concentration of oxymorphone in the blood below a certain level. Claimed a patent on that, and then used that patent to attempt to extend its exclusivity for this very old drug to 2027. The basic patent bargain is supposed to be that if you invent a new drug, you get 20 years of exclusivity, and then it becomes the property of the public, and generics can come in, and the price can be lower, and the drug can be made available to everyone for cheap. But with this type of method of treatment patent, the patent bargain doesn't work because the exclusivity for the branded drug lasts much longer than the 20 years that it's supposed to. So there were a few ways that generic companies had in the last decade to try to evade these method of treatment patents, to be able to release generic drugs despite these patents being out there. The two that I'm going to talk about today are 101 challenges, challenging the patent as directed to ineligible subject matter, and skinny labels, using a product label that doesn't describe the patented method, so that an allegation of infringement won't be successful, and you can market the drug for the non-patented uses. why would you use these kinds of evasive techniques? Why would you do that rather than just challenging the patent? Well, in the United States, Hatch-Waxman litigation where you're a generic and you're fighting to release a drug over a patent protecting branded product, it's expensive, it's long, it's very uncertain. The median cost for these suits in 2019 was $3.5 million. If the cases don't settle, the median time to trial is often over 2 years. And there's a lot of difficulty in winning. Patent in the United States is presumed valid. That makes invalidating them difficult. And if you're trying to invalidate them by proving obviousness, it's especially difficult because there's jury instructions and legal principles in the United States that encourage juries to avoid hindsight bias, to avoid looking at a combination of two pieces of prior art and assuming that it would have been obvious to combine them. So generics and attorneys for generics wanted to find ways to either avoid these lawsuits or win them very quickly so as to reduce the price and delay. 101 challenges are challenges where you're saying that the method of treatment patent is directed to ineligible subject matter under 35 USC 101. The United States Supreme Court has ruled repeatedly that while patents can be directed to compositions of matter and methods of treatment, a patent cannot be directed to an abstract idea or a natural phenomenon or a law of nature. So the question becomes whether a method of treatment patent is actually a claim to a new and innovative treatment method, or if it's just claiming the obvious application of the law of nature. The reason that you would want to do this is because these challenges typically are resolved on a motion to dismiss right at the start of the lawsuit. So it happens before any discovery occurs. If you can win a case at the outset, then you avoid all the cost of discovery and you can save millions of dollars and years of time. The Supreme Court case that opened up this option, at least temporarily, was the Mayo Collaborative Services versus Prometheus Labs case in 2012 from the Supreme Court. It held that a method of optimizing treatment was invalid as directed to patent ineligible subject matter. Specifically, the claim in that case was a method of optimizing therapeutic efficacy for treatment of an immune-mediated gastrointestinal disorder by determining the level of 6-thioguanine in the patient and administering more or less drug as needed. In other words, you look to see what the levels of the drug or a metabolite of the drug was in the patient's blood, and if that level is below the therapeutic level, you give the patient more drug. If the level is above the toxic level, you give the patient less drug. So it's kind of it's a pretty obvious type of treatment. You're diagnosing the patient, and you figure out whether the amount of drug needs to be more or less, and then you give the patient more or less drug. The Supreme Court unanimously held that this claim was directed to an unpatentable law of nature. The law of nature is what is the level of 6-thioguanine in the patient that is therapeutically effective but not toxic, and all of the claims to the method of treatment, the administering more or less drug as needed, is just routine post-solution activity. It's the obvious thing that a doctor would do, given knowledge of the law of nature as to what amount of the drug you want to have in the blood. The courts applied Mayo, and I was involved in one of the earlier cases that successfully used the Mayo precedent to defeat a method of treatment patent, Endo Pharmaceuticals versus Actavis Inc. I was on the team representing Actavis. This concerned the Opana ER drug that we discussed earlier, and the claim in that patent that was administering reduced doses of Opana ER in renally impaired patients in order to limit the average oxymorphone levels in the patient's blood. We argued this on a motion to dismiss in the District of Delaware, and the District of Delaware held that the patent was invalid at the motion to dismiss stage, avoiding all the expensive discovery and invalidating the patent very quickly, finding that the patent was directed to the natural law that, quote, bioavailability of oxymorphone is increased in people with impaired kidney function. Because that's really all the patent was claiming was, we discovered that bioavailability of oxymorphone is increased in people with kidney damage. So the obvious thing that a doctor would do is to give less oxymorphone to such patients. That was all well and good, and then the Federal Circuit ruined everything in 2018 with Vanda Pharmaceuticals versus Westward Pharmaceuticals International. In that case, we were looking at a similar method of treatment patent. It was a method of treating schizophrenic patients with iloperidone, by administering a different amount of drug depending on whether the patient has a certain metabolizer genotype. So you do a genetic test to determine if the patient has this particular genotype. That means they metabolize the drug differently. And if they do, you give them a different amount of drugs. Again, very similar claim to what was in Mayo and what was in the Endo case. But the Federal Circuit here distinguished Mayo. It said that this was not like the claim in the Supreme Court case. Oops, sorry, I accidentally clicked the slide. Because that claim was, quote, directed to the application of a drug to treat a particular disease. In other words, taking the Vanda case seriously, this meant that any patent that claimed that it was directed to a method of treatment automatically passed 101. I don't believe that is an accurate application of Mayo. I think the Federal Circuit made a huge mistake in this case, and Judge Prost dissented in that opinion, noting that the claim in Mayo had an administering step, negating that whole difference that the majority supposedly found. Again, I think Judge Prost was right, but the law is what the Federal Circuit says it is until the Supreme Court steps in and changes things. So that this is what we're stuck with. And after the Vanda decision came down, the Federal Circuit reversed the decision for activists in the Endo Opana ER case in 2019, holding that method of treatment patent was in fact valid. And generally, since then, the Federal Circuit and lower courts have applied Vanda to hold that pretty much all method of treatment patents are directed to patent eligible subject matter. There are a few exceptions that the Federal Circuit has found, often in unpublished cases. So a claim to exclude a patient from treatment rather than giving the patient a different treatment based on a diagnosis, those claims are ineligible. That's this INO Therapeutics case. A method of treatment that doesn't involve drugs is ineligible. This is In re Sunshine. That was a claim to method of weight loss treatment, where the method of weight loss treatment was essentially a diet, maybe a slightly different diet than conventional ones, but there was no drug that was being administered, and the Federal Circuit held that was invalid under 101. And a diagnosis without a treatment is ineligible, and there are several Federal Circuit cases to that effect, such as this genetic veterinary science case cited here. So 101 challenges, not really an option until the Supreme Court steps in. One of the other solutions, and one that is specifically authorized by United States statute, is the skinny label. Here, the generic company would release the generic drug, but would leave out of the label a patented indication. So when we're talking about method of treatment patents, there's never a direct infringement in these cases. Because the method of treatment isn't done by the pharmaceutical company, it's done by the doctor who uses the drug. So all the claims in these cases are for inducing infringement, for alleging that the generic pharmaceutical company on its product label is instructing physicians how to practice the patented method using their drug. In theory, a skinny label avoids an induced infringement claim because when you sell the drug, you're not telling doctors to use it to practice the patented method, so you're not inducing infringement. And also in theory, this is specifically authorized by statute. Section 355J2A8 of the Hatch-Waxman Act allows a generic pharmaceutical in its ANDA, it's abbreviated new drug application, to carve out patented uses in order to avoid infringing a patent. And for a while, again, this worked. This worked well. But then this year, late last year, and then again just a few weeks ago, the Federal Circuit decided GlaxoSmithKline versus Teva Pharmaceuticals. In this case, Teva launched a generic carvedilol in March 2007, after the original patent on the drug had expired. When it launched the drug, the label was limited to left ventricular dysfunction and hypertension, and excluded heart failure. And GSK had a patent on treating congestive heart failure with carvedilol, but its patent on the other two applications had expired. GSK obtained a reissue patent in January 2008 for treating congestive heart failure with carvedilol. And for reasons unrelated to this issue, the FDA required Teva to change its label to add treatment for congestive heart failure in 2011. The jury in that case found that there was induced infringement, and the district court judge entered a decision for judgment as a matter of law, rejecting the jury's verdict, finding that because it was a skinny label, it could not have induced infringement. The Federal Circuit reversed and reinstated the jury verdict and said that there was sufficient evidence that the skinny label induced infringement. Some quotes from the case: when the provider of an identical product knows of and markets the same product for intended direct infringing activity, the criteria of induced infringement are met. And the really scary part of this decision, GSK's expert testified that an AB rated generic means that if the generic drug is used in accordance with its label, you would expect it to have the same clinical effect. Teva advertised its carvedilol generic as AB rated to GSK's drug without talking about the congestive heart failure treatment. But the court said that was insufficient to avoid inducing infringement, because as long as doctors knew that it was an AB rated generic, doctors would expect it to work the same, and therefore that would induce infringement. But that means there's no way to avoid a method of treatment patent by carving out the patented use. And on panel rehearing, the court reiterated its emphasis on that AB rating. I did also point to some pre-2008 press releases suggesting use of the generic carvedilol for heart failure. But the key problem is this very troubling precedent that says that an AB rated generic, and a generic effect has to be AB rated to work with US FDA law, that just having the AB rating generic means that you're inducing infringement of the method of treatment patent, even though you've carved out the method of treatment from your label. So what does this mean for generics? The judge in Vanda and GSK explained the pitfalls these opinions create for generics. In Vanda, the Judge Prost noted that the patent just discloses the natural law that a known side effect of the existing treatment could be reduced by administering a lower dose to people with the right genetic phenotype. And so it allows branded drug companies to patent methods of treatment that are just obvious applications of discoveries about how their drug works. And GSK, Judge Prost was even stronger. He noted that under the majority's analysis, the difference is indiscernible between this case and one in which generics is safe. There's no instruction, in other words, from the majority in GSK as to how a generic is supposed to release a skinny label or use the Hatch-Waxman carve-out provision to avoid infringing a method of treatment patent. So at the end of the day, what you're left with is, if you are releasing a generic and you are faced with a method of treatment patent that you're trying to deal with, the Federal Circuit has removed the two easiest ways to deal with it, and you're just going to have to go at this the hard way. You're going to have to be prepared to win your ANDA case by proving anticipation or obviousness. And that's expensive, it's troubling, it interferes with the development of generics, but that is what we're left with under Federal Circuit law, at least until the Supreme Court steps in and hopefully corrects some of these overreaches. So that is all I have. Thank you.
Thank you very much, sir, for sharing your knowledge with us. So now I would like to introduce our next speaker for the session, Ms. Cindy Lee. She is the partner patent attorney of Beijing Rising Intellectual Law Firm. She had worked for the Red Elsevier China and has more than 13 years of experience in all phases of the patent law. Ms. Lee has a major in chemical processing engineering of forest products from Institute of Chemical Industry of Forest Products of Chinese Academy of Forestry. Ms. Lee is a partner and patent attorney at Beijing Rise High Intellectual Property Law Firm since 2015. Her area of practice includes patent drafting, processing office action, re-examination, invalidation, Chinese national stage application based on PCT or Paris Convention. She also counsels her clients on a wide range of pharmaceutical and chemical matters, including infringement and issues. So I now request her to share his thoughts with us. Ma'am.
Hello.
Hello.
Hello, everyone. This is Cindy from Beijing Renzheheng IP Law Firm. I'm very honored to be invited by Mark Patent to take a speech here. And my topic is notable changes in Chinese patent law that might affect pharmaceutical patent prosecution and enforcement. I will introduce our firm, the drug patent linkage system established in the new Chinese patent law, and the comparison between China and the US drug patent linkage system. Our firm has 14 years old history. Our head office is in Beijing, and we also have branches based in up to 9 cities of China. We have about 200 attorneys experienced at various fields. And we have cooperation with many global and Chinese top 500 companies. Here are parts of our clients. Our annual patent application is over 6,000 and 80% are invention. And the grant rate of invention, which needs to go through substantive examination, is up to 78%. And our annual PCT applications is about 1,000. We are first batch of Chinese national IP firm with high reputation. We also got some honors granted by some governmental organizations. And we also got awards for many of our clients. Our service includes patent prosecution, for example, patent filing, responding to office action, re-examination, appeal, invalidation, and third-party advice. Our patent search service includes patent post search, subject search, invalidation search, and FTO. We provide patent analysis such as claim chart, design around patent portfolio transaction, and patent map. We also provide IP litigation services such as consulting, investigating litigation, negotiation, and settling. Okay, now I will introduce the drug patent linkage system established in the new Chinese patent law. And parts of the content maybe have already introduced by Mr. Mark. The fourth amendment to the Chinese patent law has taken effect on June 1st, 2021. This amendment represents a significant milestone in the evolution of the patent regulatory framework in China. A particularly notable change is the introduction of a drug patent linkage system in China, modeled on the US Hatch-Waxman Act. The drug patent linkage system includes several key components. There are term extension eligibility for drug patents, a patent registration platform for approved drugs, and an early resolution mechanism for drug patent disputes. Here, I will introduce a foundational understanding of each of these components. The new Chinese patent law regulates patent term extension and patent term adjustment, both referred to as patent term compensation. PTE compensates for the unreasonable delay of the CNIPA during prosecution and therefore applies to patents in any field. While PTE is limited to drug patents to remedy the loss of patent term due to regulatory review of new drugs. Although such review of new drug is conducted by NMPA in China, PTE is granted by CNIPA upon the patentee's request. PTE shall not exceed 5 years, and the total remaining patent term after drug approval shall not exceed 14 years. The implementation rules for the new patent law by CNIPA provides more details regarding the proposed plan for PTE eligibility. The key provisions include eligible patents shall relate to a chemical drug, biological drug, or traditional Chinese medicine approved by NMPA, or the manufacturing method or medical usage thereof. The new drug product shall be a drug of new active ingredient approved for the first time by NMPA. Particularly in the case of TCM, the new drug definition is broadened to cover both innovative drugs and drugs with a new indication. The PTE equals marketing approval date minus patent filing date minus 5 years. And another provision is 1 PTE per product per patent. That is, if one drug has multiple patents, only one extension request for one patent can be filed. If one patent covers multiple drugs, only one extension on one drug can be filed. Patent must not have been previously granted PTE, and patent must have no less than 6 months before expiration. The extension request must be filed within 3 months after drug approval, and the regulation has no retroactive effect. The protection scope of the patent during PTE is limited to the new drug and the indication approved on the drug by NMPA. Now here is the platform. The patent linkage system is to require a patent registration platform where pharmaceutical companies disclose patents related to an approved drug to the public. The purpose is to encourage and facilitate the early resolution of drug patent disputes, especially in the context of generic entries into the market. Accordingly, NMPA built a patent registration platform for pharmaceutical companies to register patents relevant to marketed drugs. The platform launches on the effective date of the Chinese new patent law. The platform has referred to as the Chinese Orange Book, but its scope is notably broader than the FDA Orange Book. Pharmaceutical companies can register patents related to a chemical drug, biological drug, or TCM, while the FDA Orange Book is limited to chemical drugs. For chemical drugs, applicants can register patents regarding an active ingredient or formulation comprising the active ingredient and medical usage. For biological drugs, applicants can register sequence patents. For TCMs, applicants can register patents regarding formulation, extract, and medical usage. For the previously approved drugs, companies can supplement relevant patent information after the platform launches. Supreme Court and CNIPA announced the judicial provisions and administrative measures for early resolution mechanism for drug patent disputes. The provisions and the measures have made it mandatory for pharmaceutical companies to register relevant patents on the platform. Otherwise, infringement or invalidity case filings before court or CNIPA would be deemed inadmissible. The new Chinese patent law establishes an early resolution mechanism for drug patent disputes, which treats the drug marketing application by a generic applicant as a legalized infringement act, thereby allowing innovators to prevent the market entry of a generic drug or biosimilar during drug approval process. The mechanism stipulates both judicial and administrative jurisdictions for dispute resolution. NMPA may suspend marketing approval of the relevant drug based on the effective judgment of a court or the administrative adjudication of CNIPA. An applicant seeking marketing approval for a generic drug will be required to submit a statement regarding each patent listed for the reference product. The implementation measures provides 4 types of patent statements. The first one is no patent info. Second is the patent has expired or been invalidated. The third is the patent will expire on a certain date, and the applicant will not market the product until the expiry date. And the fourth is the patent is invalid or not infringed. A patentee or party of interest is afforded an opportunity to object to the patent statement and may file a lawsuit before a court or may initiate administrative proceedings before CNIPA. Action must be taken within 45 days from when the application for drug approval is published by NMPA. In the case of judicial proceedings, Beijing Intellectual Property Court has exclusive jurisdiction. The resolution mechanism and patent statements equally apply to all 3 types of drugs. Nevertheless, there are special regulations regarding chemical drugs as stipulated in implementation measures. Firstly, the judicial or administrative proceedings trigger an automatic stay of 9 months for the generic drug approval. Secondly, the first generic company who successfully challenges the listed patents and receives the marketing approval will be granted a 12-month market exclusivity, during which NMPA will not grant another generic. By contrast, for biosimilars and TCMs with the same name and prescription, NMPA determines marketing approval directly. And if there is patent infringement, alternative approval will be granted. Now, the third part is the comparison of relevant legal regulations between China and the US. The eligible patents of China relates to chemical drugs, biological drugs, or traditional Chinese medicines, or the manufacturing method or medical usage thereof. While for US, the eligible patent relates to human drugs, medical devices, food additives, and color additives, animal drugs, or the manufacturing method thereof, or method of using product. The PTE length of China and US is the same. The PTE calculation formula of US is more complicated than China, in which the testing phase and approval phase are calculated differently. China and the US has the same provision that one PTE only applies to one patent and one product. The US drugs applicable for patent registration platform is only chemical drugs, but China contains more types of drugs. In China, both court and CNIPA have jurisdiction for dispute resolution, while in US, only court has jurisdiction. The automatic stay for the generic drug approval of China is much shorter than that of US. and the first generic exclusivity is much longer than the US, both of which will be beneficial for the generic companies. If anyone has questions, my colleague Mil and I will be here in the QA session. You can also contact me by email. Thank you for listening.
Thank you very much, Ms. Lee, for delivering this informative presentation. So now moving forward with our next speaker, Mr. Ian Risbeck. Mr. Ian received a Bachelor of Science in Biomedical Engineering and Bachelor of Engineering in Electrical Engineering from Vanderbilt University, and has also received Master of Science in Biomedical Engineering from the University of Miami. He received his Juris Doctorate from Universidad de Los Andes. He began his professional career at Jackson Memorial Hospital in Miami, Florida, where he worked in a basic research in the area of clinical neuropsychology since 1993. In Colombia, he joined a prestigious law firm where he worked at the patent department from October 1998 to July 2003, when he co-founded his own firm. In December 2010, he formed a new firm, Risbeck and Castro. Ian's expertise lies in the prosecution and administrative, civil, and criminal litigation related to intellectual property rights. He has been called by an expert by the WHO, World Health Organization, for their impact program in order to aid in the development of legal, regulatory, civil, and criminal guidelines to fight against the counterfeiting of medical products. He has led many committees in the IP field, including having directed INTA's Anti-Counterfeiting Subcommittee of the Latin America and the Caribbean, the Colombian American Chamber of Commerce Intellectual Property Committee, and is currently the Vice Chair of INTA's Unfair Competition Committee. So now I request him to present his thoughts with us.
Jalashri, thank you very much for that introduction. I appreciate it. Let me try and share my screen here. All right. Well, before I start, I'd like to thank markpatent.org for organizing this, as well as the rest of the co-organizers, as well as the sponsor, HK Acharya, for their support in this webinar and their invitation. So with that, let me present here and move this up here. And before I start, I want to just let you know that the topic I'll be talking about is a little touchy and controversial for some people. And I'm delivering this presentation on the side of the law and in light and the view of the topic of this presentation, which is IP as a booster for developing pharmaceuticals. With that in mind, I'm going to be talking about how the COVID-19 pandemic is testing the patent system as a driver for development of pharmaceuticals. Now, before I get into the gist of the topic, I'd like to pose in my own opinion as to whether patents in particular, by IP in general, but patents in particular are a booster to the technology development. Sorry about that. Which includes pharma. And to me, the answer is yes, although it's not without absolute question. The basic premise for this, and I always spend a little bit of time on this, is, developing technology is a risky business, and there's technical risk and commercial risk. On the technical aspect, there's no guarantee that the investment that you put into developing a particular technology will be a technical success, that you'll come up with a technical solution that is viable. And even if you do come up with a solution that is technically viable, there is no guarantee that it's going to be a commercial success. There are many technological developments, including pharma products, that despite they actually work, may be too expensive, maybe have usability issues with the consumers, including for pharma products, secondary or side effects, In some cases, even aesthetics can be an issue, including size and things like that. But then the expectation of obtaining patent protection to exclude third parties from exploiting commercially that technology obviously promotes the high risk investment in developing technology. And like I said, pharma is not, it is part of this premise that I'm talking about here. And the final point on this quick analysis of whether it's a booster or not is that, to me, patented technology and the existence thereof actually helps expand the knowledge base for further production of new technology. And this last point I'll try to explain with the following slide. So imagine right here you have the technology information, which are patented technology. However, it is information available not to use because it's patented, but as a basis for other developments, knowledge sharing in general, which is part of the disclosure element of patent applications. And so let's say you have these 5 technologies available, and now you need to solve these 2 technical problems, technical problem 1, technical problem 2. So in order to do so, you go to the literature, which is basically the technology information you have at hand, to then come up with potentially, different types of solutions to a different problem. So you have here solution 1, 2, and 3 for problem 1, and likewise 1, 2, and 3 for problem 2. Now, those solutions are eventually eligible for patenting, and in doing so, create new technology that is now disclosed, even though it's patented. And in that sense, effectively expanding the technology information. And this, to me, is one of the reasons why the patent system is generally a booster for the technology of development, and including, obviously, in this case, pharma. So with that, I leave it there to now go more into the depth of my specific presentation, but it's important to keep this in mind as we'll conclude on this at the end. So now moving along, what happened when COVID-19 became a pandemic? Well, all of us were clamoring for pharma companies to come up with a vaccine, and to do so, as quickly as possible for obvious reasons. Now, some pharma companies around the world decided to tackle the problem and invest in the development of a COVID-19 vaccine. Not all, because obviously there are many pharma companies that only deal with manufacturing, or some actually purely on the distribution, and not all are directed to development, to developing new technologies. Now, of those pharma companies that actually decided to accept the challenge to tackle this issue and try to develop a COVID-19 vaccine, some were actually unsuccessful and dropped their efforts. Others, on the other hand, were able to successfully continue and were able to successfully bring a vaccine to market. And obviously, as you see in the slides, you have names that are sort of familiar to all of us in these times of the pandemic. You have the Pfizer, BioNTech, AstraZeneca, Oxford, Janssen, Moderna, Sinopharm, Sinovac, which not in all countries, all of them, but in some countries, at least for each of those, have been approved and are currently being used. Now, we expanded the use of vaccine, and we're still doing so, obviously, but then some social political effects came to be based on the vaccine. And this is where it gets touchy. So now that the vaccines are available, there are at least currently 100 countries around the world supporting the idea of a suspension of patent protection over COVID-19 vaccine patents for a few years, with the possibility of eventually extending that suspension, including, as you see here, India, South Africa, USA, Russia, but there are over 100 that's currently supported. Now, I mentioned COVID vaccines directly in a few years, but the real aspect is that this covers more than the COVID-19 vaccine. The technologies related to COVID-19. This was initially a proposal directed to the WTO by India and South Africa, and then gained support by many countries. And the idea is to eventually suspend it until there is herd immunity or something like that. So there will be an X number of years, possibly, and then with the possibility of extending that if needed. Now, having said that, there are several countries that actually oppose such a measure, including, as you see in the slides, most European countries, not all. Australia is one of them, in addition to some of the European countries. And other countries are silent, including Colombia, my own country, and Chile, among others. So this really brings us to a huge philosophical question, which is the following. If pharma companies that initially decided to invest in looking for a vaccine, including those that actually successfully developed one and brought to market, would have known that patent protection would be suspended, would they have entered the race to develop the vaccine? That is a huge philosophical question that because it wasn't the case, we really don't know the answer to directly. We won't get into the minds of the board of directors of the pharma companies or something like that. But it goes to the question of the whole webinar here, which is IP a booster to pharmaceutical development? So what I'd like to get into is ask the question of whether this patent suspension of a COVID-19 vaccine related patents is legal. And I'm going to talk about it from the Colombian perspective. I think many countries can do similar exercises. So I will touch upon these 3 bullet points and expand on each, which is, first of all, Colombia approved TRIPS in 1994 through a local law. Second, Andean Decision 486 regulates patent matters for all the Andean countries, including Colombia, which is an Andean country. And this Andean decision cannot be modified via local laws or regulations. This is very important. So no law issued in Colombia alone can modify or go against Decision 486, which regulates patents and other IP matters. Andean norms regulating a particular topic suspend local laws regulating such topics. So in the case of Decision 46, which covers trademarks and patents in general, so industrial property aspects, basically automatically suspend any laws locally in Colombia dealing with the same topic. And if the Andean Decision 46 were to be revoked for whatever reason, then the older local laws would apply. And finally, the third point I want to touch upon is Article 189 of Colombia's constitution mandates that the president issue patents for invasions in accordance with the law. So I'll talk about each of those 3 elements. TRIPS. Well, TRIPS certainly does not provide for any language talking about suspension of the effects of a patent. However, it does provide alternatives through what we all know, compulsory licenses. We heard a little bit about that earlier. Which these compulsory licenses can be issued eventually under specific limited conditions and always requiring payment. It is in fact a license. And they can be issued according to TRIPS on cases of national emergency or extreme urgencies and in cases of public non-commercial use. Now, as to Andean Decision 46, we have a very similar situation. It does not provide for any suspension of the effects of a patent. It also does provide for alternatives through compulsory licenses under, again, very specific limited condition, always requiring payment for cases including public interest and national emergency or national security. There are other cases, but these are the ones that for the pharmaceutical industry are actually potentially applicable or important. And going to the third point that I wanted to mention is the Colombian Constitution. Now, again, Article 189 of the Constitution mandates that the president issue patents of inventions in accordance with the law. Now, based on several articles in our Constitution, the Constitutional Court has clearly indicated public servants can only do what is allowed by the Constitution or the laws. Private individuals, citizen companies can actually do everything that is not prohibited by the Constitution or the law. And this aspect is going to be quite important. So what do we have up to now? We can summarize as this. TRIPS is not allowed for its suspension of patents. Andean Decision 46 does not allow the suspension of patents. Patent law in Colombia is Decision 486, which cannot be modified by any local laws, any Colombian laws. And Colombian Constitution mandates that the president issue patents in accordance with the law. So in accordance with Decision 46. And Colombian public servants can only act as specifically dictated by the law. Public servant number one is the president. So he can only act as prescribed by Decision 46 with respect to patents, which does not allow suspension nor TRIPS. So that's what we have right now. So what does this truly all mean? Well, it means that the Colombian government or the Congress cannot locally issue any mandate to suspend patent protection. So when many countries, as we have right now, although Colombia is silent, like I mentioned, are talking about patent suspension, the only way that I see that could be done would be possibly under the modification of TRIPS, or at least get a consensus at the WTO on the issue of patent suspension for COVID-19. And likewise, Andean Decision 46, actually modifying one of them would actually not help the situation. For example, if Andean Decision 46 were to be modified on its own, but TRIPS wouldn't, or there wouldn't be a consensus at the WTO, then we could act in accordance to Andean Decision, but we would be eventually violating an international treaty, which is TRIPS, having some obvious political issues. And likewise, if on the contrary, if TRIPS were modified, and Colombia would have international pressure to apply it, but Andean Decision is not, we legally would be in the same situation, which is Andean Decision wouldn't allow the Colombian government to be able to suspend patents on that issue. So basically both of them would have to go in the same direction. So my final comments on this, first, suspension of the patent system is not the same as currently available compulsory licenses, at least in these three aspects. First, compulsory licenses require payment to the title holder. Compulsory licenses are restrictive in nature. They're certainly not an open license. Whereas suspension essentially eliminates the patent for the time it is suspended. So it truly is an open license, an absolute open license with no payment and no other restriction whatsoever. So these are major differences between the two aspects, the two elements. Now, going back to the philosophical question I asked of whether pharma companies would have a dedicated research to developing the vaccine if they knew any patents right would be suspended. Like I said earlier, I don't have the answer. However, my opinion is that at least some of them wouldn't have actually entered the race. I mean, they are in fact for-profit corporations, and they obviously answer to shareholders. And my personal conclusion as to suspension or not is that any move to suspend COVID-19 vaccine patents would certainly likely put a strain, on future development and improvement of COVID-19 vaccines, as well as pharma products in general, establishing, I think, a negative precedent with respect to IP being a booster for the development of pharmaceuticals. Because certainly, one thing is to enter the game knowing the rules, and the rules in this case would be, we have compulsory licenses. I'm not saying that we should use them rampantly, but it is an escape valve for the patent system that can be used in certain conditions. And a whole different story is to have the rules changed once you've committed to playing the entire season. So, you know, which is suspending the effects of patents, which has never been talked about under the particular the clamor of all of us to get vaccines available in the market as quickly as possible. So with that, you might gather that I am a true believer that the IP system, and particularly the patent system, is certainly a booster for the development of pharmaceuticals in general. And this particular example, at least in my opinion, as I answer the philosophical question, in the sense that I think some of the companies probably wouldn't have invested the money into developing the vaccine, sort of supports that issue. And with that, I thank you very, very much for your attention.
Thank you very much, sir, for such a proactive presentation. So now moving forward to our next speaker, Dr. Andrea Suzler. She studied chemistry with an emphasis on pharmaceutical chemistry and biochemistry at the Philipps University of Marburg, Germany. She graduated with her diploma and completed her Dr. R.Net in 1990 with a thesis in the field of molecular biology. She qualified as a German patent attorney and was admitted to the German bar. Dr. Schussler founded the patent law firm Huber and Schussler together with the Dr. Bernard Haber in Munich. Her current practice involves work in the field of patent, trademark office, patent prosecution, oppositions, and nullity suits before the German Patent and Trademark Office, the European Patent Office, and the German Federal Patent Court. She also advises her domestic and foreign clients on licensing and due diligence issues, as well as she is the author of the numerous articles relating to the patenting of chemical and biotechnological inventions. Her technical specialty is in the fields of organic and pharmaceutical chemistry and biotechnology. So now I request her to share her thoughts with us. Over to you, ma'am.
Thank you very much for this kind introduction and also the kind invitation to give this talk. And okay, my talk is about managing IP in the pharma field. And these are more general considerations about the decisions to be made during patent process patenting and during a life cycle of the technology. If a new technology is developed, at the beginning, fundamental scientific and technological problems have to be solved. And therefore, the number of patent applications is low and only slowly increasing. Since the new technology originates only from a few companies, patent applications in this technology are concentrated on very few firms, companies, and these are the pioneers or innovators and are securing the basic core patents which have to be served by others later. When then the technology and the market and uncertainties have been overcome, a broad range of applications from a large number of companies develop, but the inventive character of these applications are much lower than from the innovators at the beginning. And the concentration of a ratio of applications per applicant decreases, since also the number of applications for the technology increases, they are distributed over more applicants. Then over a longer time, the number of market players and number of applications remain stable until the technology decline period begins. This period is characterized by a decreasing number of patent applications and also market players. However, at the very end of the patent duration of such a pioneer invention, the number of competitive market players, but not the number of patent applications, may increase, since the competitors are preparing for market entry after the innovator's patent has expired. In this regard, it is very important that the for the innovator patent holder to have a larger number of younger patents, which may be observed by the competitors too, so that the innovator's market position may be prolonged. A good example has been presented by Brian with the oxycodone, which has been invented 80 years ago, but the last patent expiry date that he mentioned was in 2000, will be in 2027. And if an applicant or if an inventor has decided that he wants to go or wants to file a patent, it is important that prior art search has to be made, and if no conflicting prior art has been identified, the question has to be answered where to file, and mostly applicants decide to make a national first filing, which creates a priority date, and then filing after 12 months in the important markets like Europe, USA, Canada, Australia, Japan, Korea, or China, or to make a PCT filing. The PCT is with 153 member states, and it delays the costs. But there is no patent at the end of the PCT period. But there is a necessity for the nationalization and regionalization of the application within 30 or 31 months after the priority date. And when the patent application is to be first filed, it is important that a new product is protected as broadly as possible. In the pharma field or in the chemical field, it should be possibly presented by a Markush formula, which is a schematic representation of a generic structure with several independently variable groups. And it's also a question whether to file very early with limited data and examples. This could be detrimental to the supporting generic formula and may result in limited patents during the prosecution. But if the decision is to delay the filing and to collect more data, it may be the problem that competitors may be earlier and are undermining the freedom to operate, and there is a risk of dependencies. And therefore, there's always a situation where you have to decide whether to file early and to risk only a limited patent, or to file later with better data, but then others could be earlier than you. And in this regard, it should be never forgot that application filing first is important, and then public disclosure, because most countries have no grace period. And therefore, if you make a public disclosure first, it may happen that your own public disclosure will destroy your application and no patent will be granted. And after determining the right time to file a patent application, emphasis should be put on the entire product life cycle, from discovery through the end of the patent duration. It should be tried to achieve a line extension through building a larger IP portfolio by filing of follow-on applications. And taking the pharmaceutical industry as an example, line extension strategies include finding a new and or further indication. Patents can be obtained on a compound for use as a pharmaceutical in general. This would be the first medical use. This means also compounds known from other technical fields may be again patentable in first medical use claims if used for the first time as a pharmaceutical. The wording of such a first medical use is different in the countries, but according to my knowledge, all countries have such a first medical use, and therefore you can patent a compound for the first use in the pharmaceutical field. If for known pharmaceutical further uses have been found, for example, the treatment of one or more different diseases, this may be covered in second or further medical use claims. An example is the surprising finding that the known breast cancer drug tamoxifen has potential in tackling bipolar disorder, or that the painkiller acetylsalicylic acid has blood thinning properties which make it a good anticoagulant. Or another possibility for follow-on applications is finding a new dosage regimen. It may be covered by or through second or further medical use claims. For example, if the compound has to be previously taken every day, and so a modification could be taken if it's only once a week, and this could be then patentable. The new dosage regimen could be patentable over the dosage regimen that had been found before. Another possibility for follow-on application is finding a different mode of administration. This may be covered also, so second and further medical use claims. For example, if the compound may be taken orally instead of intravenous administration before, then it's a different mode of administration and is a new patentable use. Or you can find a new combination if often the combination of the compound with other active agents or ingredients results in improved properties, and then the combination may be covered in a product claim. And to make the combination patentable, it may be helpful if a synergistic effect of the combination over the single ingredients can be shown. Or another possibility for follow-on applications is the process optimization. It is possible to protect an optimized method for producing the compound, which is, for example, faster or avoids the formation of unwanted side products. Or another possibility is finding derivatives, polymorphs, or products. And also these compounds may be patented separately as products from the first found product over, and the first found product will not be novelty destroying for these. There is for the active agent there is a lifetime cycle, and the time from inventing the lead compounds to the final active agent is most about 5 years, and where the pharmacology and toxicity testing has to be made. And then from the clinical phases 1 to 3 until market authorization are again about 5 to 7 years. And thus, if for a new compound coming to the market, often more than half of the patent duration of 20 years is over. And therefore, there are different measures for prolonging the IP lifetime. These are the supplementary protection certificates, the SPCs in the European Union countries and Iceland, Switzerland, Liechtenstein, and Norway. There is a maximum of 5 years after patent expiry. It's calculated on the base of the patent application date and regulatory approval date. And there are additional 6 months for pediatric use. the calculation is similar to what Mr. Toby Mack and Mrs. Cindy Lee has presented for the PTA in China. And the aim is to restore 15 years of effective lifetime between the application and the first and coming to the market. And there's also the data exclusivity, which follows the market authorization. It's under the European law. It's a period of 8 years from the initial authorization of a medicine, during which the marketing authorization holder benefits from the exclusive rights to the results of preclinical tests and clinical trials. After this period, the marketing authorization holder is obliged to release this information to companies wishing to develop generic versions of the medicine. But this gives the original or the originator more time to have a benefit of his invention and of his patent. And if there is a patent granted, possibilities to exploit the value is, of course, the own use, or there could be licensing, including franchising or merchandising. And for example, if you're a small company and you have, for example, found out a dermatological drug, and the further indications that you find is perhaps a neurological disorder to be treated, then for the small companies, it's probably very difficult to have the resources to support the new use. And therefore, it may be advisable to license that business out to a more experienced partner in exchange for agreed royalties. The same could apply to an alternative formulation that may require outside expertise. Licenses will typically include milestones. These milestones may be based on regulatory steps. Perhaps the licensee pays to the licensor an agreed amount when regulators approve the use of the compound. Or the milestones may be sales-based, with the partner's royalty slice increasing once sales reach specific levels. And the licensing incentives the partners to keep its side of the agreement successful, and but any improvements that could be achieved during the collaborations will create perhaps new IP coverage, and may also give some dependency of the partners to each other. And another possibility to exploit the IP is selling the IP, that's of course, but IP is also very, very important for raising finance, because these companies funding startups, they want to see patent protection or at least filing of an application, and therefore patenting are boosting the whole system, because without any without patent filing, there will be a gap in finance, and the funds will not be released if there is no patent protection on the horizon. And also, your IP can be very good used for building up strategic partnerships with smaller or larger companies, and to do things together. And IP is important, that everybody knows which is coming from which partner. And during the lifetime of a patent, there is also at every time the decision to make whether the patent should be maintained, because annuities or maintenance fees have to be paid within certain periods. In Europe, you have to pay it annually, every year. In USA, you have to pay it after 3.5, 7.5, and 11.5 years. And therefore, I think, but the decision whether to maintain the patent, it should be kept in mind that the pharmaceutical industry, that the value of patents are often over 10 years, and therefore you have to pay for it. And there's also the product, there is also the problem in the IP management, whether to maintain the patent, if it's not successful from the beginning on, whether the market is already ready for the product. And sometimes also, which has to be considered, is that technological standards could change over the lifetime of a patent. And therefore, there is no golden rule, in the sense that one decision fits all, and there is it must be decided on a case-by-case basis whether it's whether the patent should be held or whether it should be given up, because sometimes the market changes, and patents that have been given up too early would be valuable after only after some time. Now I come to the end of my talk, and I think questions will be answered later on. And I thank you very much for your kind attention, and thanks again for the invitation.
Thank you very much, ma'am, for enlightening us with your thoughts. So as I see, all the questions have been answered either in the question answer box and the chat box. But if any of the panelists would like to give highlight and for the better clarification, the stage is open for the discussion. Mr. Toby Mack, would you like to add something?
What specific topic do you want me to add?
So the question, just hold on.
No problem. Yeah, I have one thing to add is about the type, the first contentious patent linkage declaration. Wait for me a moment.
The percentage, do you know the percentage filed abroad of all the Chinese patent applications?
Yes, the conversion rate is about 3.4. Sorry, 3.7. And again, the number is quite consistent as in 2019, according to the CNIPA statistics.
Mr. Brian, would you like to add with your question that what are the changes you see due to revised double prolonged allies and Mayo test in 2019 PEG issued by USPTO?
So I answered this in text in the chat. But the basic problem is that whatever the Supreme Court intended in Mayo and whatever the detailed guidance in the 2019 USPTO guidance is, the problem is the Federal Circuit's Vanda decision says that if the patent claims a method of treatment, it's eligible at step 1, and there's not really any good way to get around that if you're generic. So Vanda really is a big problem in this area, and if you're generic at the moment, you've got to deal with it. I hope that the Supreme Court will.
The question again for the Mr. Raisback, that regarding the suspension, Mr. Ian.
On this, I can't see in the chat. Are you talking about the potential abuse of pharmaceutical companies?
that such action will cause extension of the patent if granted regarding the pharmaceutical company. Yes, sir.
You know, that specific, I think, will go country by country. If, for example, I mean, a suspension is a measure that, as far as I know, in most countries that I'm aware of, it doesn't exist. And in that sense, to try to equate extension of term because of prosecution delays with extension of term because of a suspension, it's just a whole different aspect. So, and I'm not sure that was the intention of India and South Africa when they requested they provided the proposal to the WTO, but basically a suspension so that other people can enter into manufacturing to provide a higher volume of vaccines to many more people as quickly as possible. Having said that, in Colombia, the patent extension is available, but not for pharmaceutical products. So in Colombia itself, that you wouldn't be able to even talk about equating those two aspects. And in terms of a suspension being ending in an abuse by pharmaceutical companies, you know, it's a difficult question to ask, and it's a difficult question to even answer, because what is meant by abuse? You know, you have two sides, and is it abusive if you're a pharmaceutical company that you entered into the game with certain number of rules, and then they change completely, and there's money invested, or is it abusive to try to change that the rules of the game in the middle of the game, or is it abusive that maybe some would try to slow down manufacturing? I'm not sure if that was what was intending to sort of as a kickback mechanism on, or if this situation were to happen. It's really difficult. I mean, I think it's too of an open question or statement to even tackle. There's certainly many positions, and like I said at the beginning, this is a touchy subject because of what it means socially. But at the end of the day, we're talking about in this webinar of, is IP a booster for pharmaceutical development? And I think the discussion itself would lead someone to believe that if the patent system works as it's intended to be in general, then it certainly is a booster. And the fact that some pharmaceutical companies, in my opinion, might have decided not to enter into investing in the vaccine if they knew they could have been suspended if that were a rule beforehand, means that truly the patent system is promoting some companies to invest in developing technology, whether it's pharma or any other technology. And that's the important question to be asked here. The ethical, social, political, and other aspect details are just opinions that at the end of the day can come to a conclusion that may end up legally based, legally bound. But it's difficult, and I think too time consuming, you know, we could talk about for days on the ethical issues on both sides.
Can I add something about Ian's comments?
Yes, sir.
In fact, I have asked several of my clients what would they do if there is no patent protection for their technology they develop. And their answer to me is, they will stop doing that. And even if their engineer did not listen and make something new, what they would do is try their best to keep all of this secret. And to me, the message behind is this would lead to the entire society to have to spend a lot of resources to reinventing the wheel a lot of times, which is in fact a waste of the resources of the society. And is that the direction that we want to go to? Of course, that's a matter of choice. But for me, I don't think that's a good choice.
The panelist would like to add something. Okay. Thank you, everyone. So now, moving forward, I request Ms. Kinjal Shah to appraise this virtual gathering with her vote of thanks. She is a patent attorney and worked with the patent division of HK Acharya and Company. She holds a bachelor qualification in biochemistry from Gujarat University and also a master degree in science with medical technology from Gujarat University. Her work incorporates prior art search, drafting of patent application, and replies to the office actions. Her training is related basically with the patent indictment and opinion work, and essentially in the field of biochemistry. So now I request her to deliver a vote of thanks.
Thank you, Ms. Jalashree. Hello, ladies and gentlemen. It gives me an immense pleasure to deliver the vote of thanks to all the dignitaries assembled over here for this webinar. And I'm Kinjal Shah. As we have come to the end of this webinar, I wish to thank all those who have contributed to the successful conduct of this webinar. First of all, I would like to thank the Managing Trustee of markpatent.org, Dr. Rajeshkumar Acharya. As everyone knows, we can't connect physically right now due to this pandemic, but from the efforts of Dr. Acharya, we are gathered virtually. So thank you so much, Dr. Acharya, for arranging this kind of wonderful and very informative webinar. I would also like to thank Mr. Padmin Buch, who have delivered his knowledge about global pharmaceutical market and the Indian pharmaceutical scenario and few issues about the pharma industries. Thank you so much, Mr. Buch, for providing such a thought-provoking information. I would like to thank Mr. Toby Mack, who has provided his knowledge about Chinese patent system changes, who has also provided such a nice information about the 4th amendments in Chinese patent law. Chinese patent drug patent term adjustment also provide a knowledge about term extension, their limitations, and drug patent linkage database. Thank you so much, Mr. Toby Mack, for providing this information. I would like to thank Mr. Brainback, who has provided knowledge about the barriers to challenging the method of treatment, who has extensively provided a knowledge about the method of treatment in their countries, and also provided knowledge about federal circuit steps. Thank you so much, Mr. Back. I would also like to thank Mr. Cindy Lee, who has provided notable changes in Chinese patent law and also continue their knowledge about a drug patent linkage, a Chinese patent term extension, and the patent registration platform. She has also provided a comparison between the Chinese and US patent. So thank you so much, Ms. Cindy Lee, for providing such a helpful information. I would also like to thank Mr. Raceback for providing such a knowledgeable information about how the patent is a booster for the technological development, including pharma industries in Colombia. Thank you so much, Mr. Raceback, for providing such information. And I would like to thank the last speaker, Dr. Andrea, who has provided a pharma patent procedure or pharma patent strategies in Germany. Thank you so much, ma'am, for providing such a nice information. And it is very helpful and very useful to us. I thank to the sponsors, HK Acharya and Company, the co-organizers, Xavier's Research Foundation, GLS Law College, ICFAI Law College, Hyderabad, USLG, University School of Law, Gujarat University, and USIIC. For their wholehearted support as co-organizer and organizing this webinar. I will be failing in my duties if I do not express my sincere appreciation to the technical team of markpatent.org for enabling the smooth conduct of this webinar. Last but not of the least, a big thank to all the participants who have taken off to participate and for making this webinar a big success. Thank you and have a wonderful weekend.
Thank you very much, ma'am. In closing, I wish to express my gratitude to all the delegates and observers for their full cooperation and active participation. I would like to thank all the wonderful people who spoke and enlightened us with their amazing knowledge and ideas. It's been an honor to among the such an accomplished individuals. Thank you all for your patience. We are privileged to have in attendees such a distinguished experts as well as observers. Having such a resourceful and knowledgeable delegates which have helped us to gain insight on strengthening mechanism as a means of promoting IPR. We convey our sincere appreciation to our distinguished guests who have been actively participating from all way across the globe to make this webinar a huge success. I wish you all a blessed and a good day. A very good morning to Mr. Beck and Mr. Reisbeck. Good evening to Ms. Cindy Lee and Mr. Toby Mack, and good afternoon to Dr. Andrea. So with this, we sum up our session. Thank you, ladies and gentlemen. Wish everyone to stay home and stay safe.
Thank you, everyone.
Thank you. Thank you all. Thank you all of you.